Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. The tragic death of 7-year-old Megan Conca by a convicted sexual offender who lived across the street from her galvanized her parents and communities all across the country to pass Megan's Law. Today we'll find out how Megan's Law is implemented and its impact on neighborhoods who have sexual predators in their midst. Our guests are Lucinda Suarez, Deputy Chief of Special Victims Bureau of the Queens District Attorney's Office, and Ron Kuby, a noted criminal defense attorney. Hello, Lucinda. Hello, Ron.
Hi.
Hi. Lucinda, tell us, what is Megan's Law?
Megan's Law is a Sex Offender Registration Act. All of the states currently have a Sex Offender Registration Act, and some 25 states have community notification sections regarding convicted sex offenders. Essentially, if you're a convicted sex offender in New York, you must register, you must be assessed, your risk level must be assessed at first primarily, and then after assessment, you must register periodically with local law enforcement where you're living, what you're doing.
And Ron, what happens then? They register with the local law enforcement, and how does it affect the community? What happens?
Well, depending on your level, and if you're right at the highest level, the sexually violent predator, which means you committed a crime that received a lot of publicity, what happens is your name, location, your address are publicized.
How is it publicized?
Right now, there's proposals in place to actually put it on the internet, so people can go surfing the internet and discover that the guy down the street, despite the fact that he may have lived a law-abiding life for 5, 10, 15, 20, even 30 years, was a convicted sex offender years and years ago, and then they can round up a bunch of people and picket his house and force him to flee the neighborhood.
Well, there's some inaccuracies here. You're not rated a sexually violent predator, a level 3 under New York statute if your case received publicity. There's a very detailed risk assessment instrument under which a board of sex examiners decides whether certain factors apply. And the factors are meant to determine the risk to the community at large.
Except, of course, that there are overrides that are in place. So if your case was a notorious case, a highly publicized case, they simply plug in one of those overrides and boom, you're on www.com, pervert, hound them out of town.
That's just absolutely not true. The overrides, one of which is that you cause serious physical injury to your crime victim during the course of the rape. That has nothing to do with whether the case was in the newspapers or not. If you've caused serious physical injury to that crime victim, then an override would apply. And in the mind of the board and our legislature, when they passed this statute, they considered that person very violent and the protection of the public important enough to rate that person a level 3.
Now, Ron, you represented the gentleman who was convicted of the Central Park jogger assault, rape.
Yes.
Now, I assume he is part of Megan's Law and a sexual offender.
Yes.
I know he's out of jail now.
Yes, he was released from jail. This is Yusuf Salam, who was convicted of what we all have to acknowledge was a terrible, violent, awful crime.
Yet he only did 3.5 years in jail.
No, he served 7 years in prison. He served virtually his entire prison sentence, maintained a perfect prison record, went to sex offender counseling, sex offender treatment while in prison, was examined by a defense psychiatrist and pronounced to be of no danger to anyone, put on a case involving character witnesses, ministers, imams, psychiatrists, people from the community, people who had known him and people who had come to know him, all of whom testified that this man constitutes one of the lowest risk of offenders they have ever seen. But because 7 years ago he had caused that serious physical injury, that's all the board needed and that's all the judge needed, and they labeled him a sexually violent predator, despite the fact that he constitutes virtually no risk of reoffending. And as soon as he got that label, the first thing that happened to him, of course, was he lost his job. And of course, that is exactly the kind of retribution that Megan's Law encourages.
What has been your experience with the board? Is it different than Ron is pointing out?
The assessment has nothing to do. There are no extra points given to someone based on whether the case was in the newspapers or not. The extra points are given when when you don't know the crime victim. Someone who will attack a stranger on the street is considered much more of a risk to the public at large than that relationship is established to hurt this person. They're considered much more dangerous than other types of sex offenders. Like, for example, a typical level 1, which is the lowest risk level. Risk of re-offending and risk to the community at large would be a statutory rape case. A 22-year-old who has consensual sex with a 14-year-old. That would probably be a level 1 type case. The type of case that we're talking about here is a group of people who attack a stranger on the street and cause serious physical injury, near death to someone. That's a risk to the public.
On Megan's Law, other than putting it on the internet, potentially, are the neighbors actually notified that in their midst, down their block, right next door, is someone who has been convicted of a sexual crime?
There are several community notification sections in New York law, one of which is a statewide directory which lists level 3 offenders, their names, their addresses, their photographs. And the public can get access to that directory if they make a statement in writing expressing a purpose for the need.
Okay, but the neighbors are not contacted, a sign is not placed in their local community center?
Excuse me, but what's going on now, because these mechanisms are so cumbersome, district attorney's offices and the attorney general are talking about new ways to publicize names, new ways to paint the big scarlet letter on people's foreheads so the neighbors do find out. The complaint among law enforcement is that the neighbors don't know yet. The procedures are too cumbersome.
Can you imagine there be some circumstances that people should know that there's a sexual offender living in their midst?
Look, you know, we live in a society where there are all kinds of people running around. You know, who am I afraid of? I'm afraid of anti-abortion clinic protesters. That's right. These people scare me to death. I want to know if one of these right-wing, so-called pro-life wackos is living near me because of their propensity to pick up guns and go blow people like me away. That's my particular area.
I understand. But now going back to what we're referring to here, do you see any notification requirements?
I don't.
Any circumstance?
I really don't, because I think that we hit the wrong target out of panic for the wrong reason and do tremendous damage to everybody. For that small group of identifiable child sexual offenders, like the person who killed Megan Kanka, Jesse Temendekwa, who had a repeated long history of violent sexual offenses directed at children, was incurable, and we all know that he was incurable. Something must be done to sort of specifically target those people and make sure they are not in a position to prey on children. But to pass a broad brush piece of legislation that takes somebody who in fact did, 30 years ago, an 18-year-old boy had sex with a 15-year-old girl, he was convicted of statutory rape. He is now part, 30 years later, of the register.
Okay, how do you respond to that?
Many objections. First of all, 30 years later is just not the case. We're not applying this law retroactively. And secondly, that type of offender, the statutory rape, is a level 1 for which the community is not getting notification.
I'm sorry.
In addition to the statewide
retroactivity, I'm sorry, that's just wrong. I mean, the reason it is not now being applied retroactively is the Court of Appeals has stayed the attempts of people like Cindy Suarez to apply it retroactively. As soon as the court lifts that stay, they're going to be applying it retroactively, and they want to apply it retroactively.
Well, interestingly enough, there is no role for the district attorney's office in Megan's Law, in our New York's Megan's Law. The statute is completely silent and doesn't mention the district attorney's office. It mentions the Attorney General's office as the office that would uphold the constitutionality of the statute. And so really the role of the district attorney in this law, in implementing this law, would be when judges require information regarding the underlying facts of the crime for which this person stands convicted. We would respond to a judge's request for information. We do that all the time in Queens County.
And how do you respond to Ron's point that he doesn't think this law in any form is a valid law?
Look, underlying the policy for this law is the fact that sex offenders are known to be repeat offenders. Underlying the policy of this law is a belief by our legislature and by the legislatures of in every state of this country that people are entitled to protect their children, that law enforcement needs tools to protect the community from repeat sex offenders.
Underlying
the
this-
risk assessment that is done is an attempt, no one has a crystal ball, but it's an attempt to isolate those people who are sexually violent predators, the most likely to re-offend, the most dangerous to the community at large, and certainly someone who attacks a stranger on the street is a danger to the community at large.
Does a sexual offender have to register if they go into a new jurisdiction or go to a new state?
If the
Yes.
state has its own version of Megan's Law, then they do. And every state,
Is it a crime not to register?
in New York it is, and in states that have Megan's Law, it's a crime not to register.
The first offense is a misdemeanor and the second offense is a felony in New
That's
York.
very serious.
Yes. You know, this is not unlike what conditions of parole and probation. Once you're a convicted criminal, you have to notify parole and probation of your whereabouts. We've
But of
had
course,
these
parole and
types
probation
of law
does not
enforcement
put
tools.
your face and your address on the internet. Does not say to the neighbors, "Hello, we have a pervert here. You should go out and hound them out of town." And what we have seen in this law over and over again is out of a commendable desire to protect children, which everybody wants to do. We have legislation by panic, and as a result, we have a situation that makes it almost impossible for whole classes of offenders to be rehabilitated. I mean, it's very hard to situate yourself in a community and try to live a life as a rehabilitated person when the neighbors are out there with picket signs throwing rocks through your window. We've seen repeated episodes of vigilante action directed at sex offenders and people believed to be sex offenders. One poor guy simply happened, the lynch mob went to the wrong house in New Jersey and beat up somebody who wasn't even a sex offender by mistake. And lastly, and probably more importantly, we're not doing anything to protect children in any way, shape, or form. It's a false panacea, especially in a place like New York City, to think that by knowing that 7 of the 10,000 people you're likely to see on the subway at any given time are sex offenders, you're somehow in a position to protect your children. That's ridiculous.
Lucinda, how do you respond to that?
The law is not meant to as a panacea. That's the only point on which I agree. However, the law is a real attempt to help people protect their children. If a sexually violent predator, someone who's been convicted of child molestation, lives on your block, the law is that entities with vulnerable populations, if there's a school across the street, that principal deserves to know that there's a convicted child molester living across the street, so that they can take appropriate steps to safeguard the safety of those children.
Such as what? What should they do? You're a district attorney, you're deputy chief of the Special Victims Bureau, which is the Sexual Assault Bureau in Queens. What should the principal do?
The principal should get a mob of parents together.
Certainly the law doesn't
picket that
condone
house.
vigilantism.
That's
It's
obviously-
against the
of
law.
course.
Certainly
yes.
the law and
But
doesn't
as a
condone
public
violence.
official, what would you want the principal to do to protect?
They could take extra safety precautions.
Like
They could have extra monitors in the schoolyard.
Okay.
They could watch. They could watch over the children more carefully. I think that what happens in our society is that you get lulled into a sense of false security, that, oh, the children are safe, this is a good neighborhood, this is a safe school.
You know, I don't think
people need to
anybody
take
in New York
precautions.
City thinks that any neighborhood is a quote-unquote safe neighborhood. I think everybody in New York City and hopefully in other communities as well recognize that you have to take extra precautions all the time, whether there's Megan's Law or not. You have to watch your children. But the sad fact is most sexual offenders who prey on children aren't just some stranger lurking in the bushes, and Cindy knows this very well. Most of the sex offenders who prey on children, especially repeatedly, are beloved family members, Uncle Charlie, who always wants to babysit, and the like. And those people are, in fact, seldom prosecuted, and in fact, seldom fall within the purview of Megan's
And
Law.
we'll continue with discussion right after this break. You're watching Lawline. I'm Alan Schnoben, your host. Stay with us.
The air dances with the waters, which brings the rain that feeds the land, that is home to the animals. All life dances together.
In a world so connected, choosing one environmental cause can be hard. EarthShare is 40 environmental charities working together. You and your company can help by calling 1-800-MY-SHARE.
All life lives, or doesn't, together.
me. Do you wear your safety belt?
Why, no. I don't wear my safety belt.
Thank you.
You could learn a lot from a dummy. Buckle your safety belt.
Who is that swimming?
Doing good, Al. I'm swimming. Try to get your legs up. Like this?
That's the way. Where's your kicking, Al?
That's right.
That's it.
I'm almost there.
Okay.
I'm almost there, Mommy. I'm almost there.
Whoa, you made it all the way.
If you don't stop your friend from driving drunk, who will?
Good job.
Do whatever it takes.
Are you having a good time?
Yeah.
Hello, you're watching Lawline. Today we're talking about Megan's Law. With us is Lucinda Suarez, Deputy Chief Special Victims Bureau, Queens District Attorney's Office, and Ron Kuby, a noted criminal defense attorney. Before the break, Ron had said that, in his opinion, most sexual offenses of children occur within the family unit and go unprosecuted. How do you feel about that?
Well, first of all, they don't go unprosecuted. When they come to the attention of law enforcement, those cases where we have the evidence are prosecuted.
I think what he really meant was within the family, they hide their own shame.
Well, those children eventually disclose, and we have a new law. It's a course of conduct, sexual conduct committed against a child less than 11, which has extended the statute of limitations. So we're going to see more prosecutions of child sex abuse cases in the future. And certainly every year the numbers do go up because more children are disclosing.
Lucinda, how do you deal with a child who has to tell you about a sexual experience or a sexual assault on them?
Interestingly enough, it's easier for children to tell a prosecutor or a teacher or somewhere else other than the non-offending parent or caregiver because and they often do tell a third party. They tell at school, and that's why we have mandated reporting of child abuse by teachers. And that's how most of our cases come to law enforcement, through those mandated reports, when children disclose to a third party that they're a victim of a sex abuse or physical abuse.
A case comes to mind in California, one of the longest running cases in the history of California, which of course ended in not a conviction.
The McMartin.
The McMartin
child
case.
abuse case.
How would you avoid that happening here in Queens County?
I don't want to comment on a prosecution in another state
how would
that I
you
wasn't.
avoid that happening where people are accused, and obviously the jury said falsely?
The way it's handled, and I've dealt with
what a jury.
cases too, is you do thorough investigation before you make arrests. You have a solid case, and they didn't have that in California. It's completely different from the vast variety of sexual offender cases that are prosecuted by the district attorneys here in New York City. I mean, nobody is claiming that the DA's offices or the AGs are being too aggressive in going after sexual offenders. To the contrary. For too long, sexual predation on children, particularly by family members, has been tolerated, has been winked on, and children have been disbelieved. What we're talking about is
By their families.
By their family members.
Not by the prosecution, not
Right.
by the people.
What we're talking about with Megan's Law is not, unfortunately, a law that's directed at that tiny minority of repeat stranger child sex offenders. We're talking about a law that singles out sex offenders, whether they be statutory rapists from 30 years ago or multiple violent sexual predators, tars them all with the same brush, makes it impossible for any of them to rehabilitate themselves based on this notion that you can predict future dangerousness, which we all know is one of the most difficult things.
So, Ron, as a father, if a neighbor moves into my neighborhood, and all of a sudden I see he's playing with my young children on a continuous basis, and my wife and I discuss it, and it raises questions in us, wouldn't we be entitled to know if this particular man who's playing with our children, which we find is odd to start, has a sexual history?
Any rational person would want to answer that question, yes. But here's the problem with answering it yes. Once you carve out that area, where do you stop? I mean, he's got a car, and he seems to drive sort of erratically. Do you want to know if he has a history of drunk driving? He's got a gun, which is his constitutional right. Do you want to know if he has a history of hunting accidents, of firearm safety? I mean, how much are we entitled to know about our neighbors, their past, their history, their crime? crimes, and how much really becomes their business after a passage of time after they pay their debt to society.
A conviction is a public record, and the plain fact of the matter is that the citizenry as a whole can't just go to criminal courts and obtain those public records. All that our sex offender registration law does is provide a mechanism by which ordinary people can find out information which is in any event public. It gives them access to information which in any event is public.
Lucinda, I know you prosecute.
And once, if I can just add something, once you've been convicted of a crime, you do give up certain liberties. We can incarcerate you for long periods of time. We can take away your liberty. What greater right do you lose?
You know what? You lose the right to rehabilitate yourself and reform yourself after you've paid your debt to society. You lose the right to say, look, I paid with 5, 10, 15 years. I'm a free person now. Let me work and let me live in peace.
Lucinda,
what we said is, as conditions of probations of parole, that these sex offenders not work with children, not apply for jobs in schools. And too long we've relied on schools to check on people. And what we're saying with Megan's law, New York Megan's law, is, you know what, we can't rely on all the institutions to do the regular checks.
Let's turn everybody into a police officer.
We would like to give some information to the public.
Help me. Do these sexual offenders of children, do they fall into certain categories? I mean, is there any way that you could say, yes, they're similar like this, they all have this, they all have experienced the following, they all have a history such as the following?
One of the things, I've been a child abuse prosecutor for many years now, and one of the common characteristics we see is that oftentimes there is not just one victim. There are many victims, many child victims, and so that we see that people who prey on children prey on a great number of children. It's not just usually one victim. Oftentimes the prosecution can only bring one case because some of the children are too young to testify. Some of the children are disabled, they're mentally impaired, and so they're not competent to testify. So there are many inhibitions or prohibitions or on prosecutions that can be brought. But what we've seen over the years, and I think what prosecutors everywhere see, is that people who prey on children prey on more than one child.
I
and
understand.
It's not just their son, their daughter.
Is it a mental illness?
Friends.
Is it?
Look, this is an area that many people study, and there are many unanswered questions, but clearly there's an impulse control mechanism that's
Now,
missing there.
Ron, I know you represent people who are accused of sexually abusing children. Have you found, at least of these people who are accused, some common threads is that parents could recognize in other people? Forget about Megan's law for the second, but that you could say, I know it could be anywhere from a business person to a bum on the street.
There's no sort of magic checklist by which you can, he seems to wear his suit in a strange way, or he talks in a particular manner. The checklist you can use, but law enforcement clearly has developed a fairly good, and I think psychiatrists agree that while you can't predict future dangerousness generally, there is a small, tiny percentage of those sex offenders for whom you can say with a reasonable degree of certainty that if released and under
they'll do it again,
they will reoffend. So the real question should be, what do we do about those people? And
what offenses are those?
Well, those
that normally reoffend.
A lot of different kinds of offenses, but when you're talking about sex offenders, you're talking about people who engage in acts of sexual predation on children. And the people who engage, particularly in violent sexual acts, and particularly when the children are strangers to them, are likely to offend over and over again. But that's the tiniest minority. And we can isolate those people, and there are things that we can do. I mean, I'm not trying to be a big liberal about this, turn everybody loose on the street to prey on everybody. You can have, instead of using incarceration and this punitive model, you can say, look, these people are ill, and they have impulse control. So what do? Well, let's put them in an assisted living situation where instead of spending millions of dollars to incarcerate them, where they become even more brutal and brutalized, put them in a situation, a sort of structured living situation, where they can't come into contact with children, instead of incarcerating them. And maybe some people have to live that way their whole lives.
But of course, if there is this minority that continuously cannot control these impulses, which you've said, isn't this the reason for Megan's law, that the that the public should be protected?
No,
that I, as a father,
Yes.
should
But
know
That's the problem.
about this people who are playing with my children?
Megan's Law doesn't do that. Megan's Law paints with a very broad brush and doesn't provide any mechanisms by which you can prevent these people from reoffending. I'm saying, look, if the real problem is the 1% of sexual offenders who prey on children who reoffend, let's target those individuals. Let's put them in some sort of assisted living situation where they don't come into contact with children, and we have solved the problem. Let's not turn every citizen into a police officer and every citizen into a potential lynch mob, picketing every other citizen's house by virtue of their prior criminal acts.
Lucinda, let's talk about the nanny case in Massachusetts in the moment that we have left. What's your take on that particular case and the appellate review of it?
I think clearly everyone knows that shaking a baby is criminal behavior. I think that's clearly the message that we have from that case. I think that the public is probably very confused about the fact that the jury came back with a verdict and that the judge was able to
So no one is saying that this nanny took the baby and threw the baby against the wall?
No one is
They're saying that she
shook her so violently, so repetitively, so hard, that the baby's brain was scrambled.
Well, there's also blunt trauma to the back of the head. There was a fracture, and the argument as to when that fracture was there, but clearly the baby had a skull fracture. So you're not just talking about shaking, you're talking about shaking combined with impact.
Well, the baby also had a broken
potentially
wrist.
an impact.
Yeah.
The baby also had a broken wrist. Contested was whether that was an old fracture or a new fracture. And so if we put that issue aside, I don't think that there was, she had diffuse brain injury.
And
usually with a blunt impact,
on what the
you're going to
judge
have a localized brain
and
injury.
as far as what the judge did reducing
I
the
think
charge?
probably the public is very unhappy.
What about you? You're a prosecutor.
Very unhappy.
Ron, what's your take on it?
Well, my take was that she was treated much too harshly the first time when the jury convicted her of murder and she was sentenced to life in prison, and much too leniently the second time when she walked out of prison.
Big diversity, just too big a gap.
Right, I mean,
Exactly.
there's a middle ground between putting somebody in jail for the rest of their life and shaking their hand and giving them a plane ticket.
Don't you now have a case pending where Lucinda is the prosecutor on a case?
I'm happy to say that I am no longer on that case. It's a tragic case.
Tell us about it.
A physician, Dr. Malcolm
Quickly.
Stewart, anesthesiologist, a loving parent, a loving father, falsely accused by Cindy Stores of shaking his little infant daughter to death when she, in fact, had pre-existing medical injuries. And this is part of the tragedy of shaking
I'm not
baby
going to ask you to comment on the case, but just, I assume that'll be coming up. And again, that's a
The
shaken
trial
baby.
will be coming up.
And that's a shaken baby case.
Yes.
So we'll be reading about that case.
Yes.
Lucinda Suarez, thank you very much for appearing on Lawline. And Ron, thank you once more.
Well, thanks once again for having me.
Okay. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.